think I used to have one of those.
And if I found a challenge coin I'd left, there's so much that I'd left behind in that desk.
See if I got bounced off. Remote access.
Bounced off.
Nope, still on it. You have what?
Charging cord.
Oh, for the phone?
Yeah, case.
Okay, that's good to know because
Too.
I'm on a wireless hotspot, so I'm not sure.
Oh, I should have brought my
You're what?
phone. They haven't given me like instructions about how to mail it back. I keep forgetting to actually bring it. Give it to you and you could brought it back.
That's a good point. Although I'm not accepted for anything else at the moment, so.
Still bet you'll be in before me.
Well, yeah, I would talk to Akis. He could probably mail it. He mailed me a computer during telework, maximum telework.
Yeah.
He mailed one up to New York for me when I was staying with my in-laws.
I was just thinking.
I found a good bit in the LCAS. There's a nice piece here in the LCAS, in the EA.
How do we turn the sound off now?
Okay.
How do I turn the sound off on these?
Here, the lower right corner.
I know, but it,
Good afternoon. Please be seated. Annie, would you please call the next matter on the court's calendar?
Time set for a hearing on motion in case CD-24-168-M-ELC, Center for Biological Diversity et al. versus Carey et al.
Okay, counsel, good afternoon. Ms. Bronston, Ms. Ackland. Ms. Bronston, are you going to argue?
Yes, Your Honor.
Okay. And Mr. Duffy, welcome back. Are you arguing or Ms. Polacek?
With Your Honor's permission, we would like to divide the argument.
That's fine.
Okay.
Okay. So you've both got 45 minutes. I assume you'll want to reserve some time for rebuttal. We'll start with the plaintiffs, and then rebuttal. Plaintiff will go first, then defendants. So let me know if you want to reserve some time. Obviously, I've read a tremendous amount as it relates to this case. I mean, this is not my first go-around with this case. We had the preliminary injunction hearing, and so I've read, obviously, all of the briefs and a lot of the administrative record. If there's certain things you want me to focus on in terms of the administrative record, be sure and call those matters out. Okay, Ms. Bronston.
Is it probably a little high? Yeah. Okay. Good afternoon, Your Honor, and may it please the court. Allie Bronston on behalf of plaintiffs, and I am here with my co-counsel, Christine Ackland. I would like to reserve 5 minutes for rebuttal.
All righty.
And for the sake of time, as to plaintiff's big game claim under a FLIPMA, we think that that claim is straightforward, and I plan to rely on our briefing on that matter, unless the court has any questions, which I'm happy to address. Second, I would like to touch on the agency's failure to consult on bull trout. Third, I will address the lynx habitat issue, which is threefold. And then I would like to revisit our conversation about Project Haul Roads and their impacts to grizzly bears, which we addressed at the preliminary injunction hearing in June. And finally, with any remaining time, I will address the cumulative effects issue and plaintiff's related motion to supplement the administrative record.
Okay.
So the bull trout issue, Your Honor, is that the agency's failure to consult or engage in any consultation regarding the project's effects to bull trout is a violation of the ESA. And the ESA requires that action agencies engage in either formal or informal consultation with the Fish and Wildlife Service if a species or its critical habitat may be present in the action area. And it is undisputed that bull trout and bull trout critical habitat are present in the Clark Fork Face project area. Yet nothing in the record indicates that the BLM and the Fish and Wildlife Service engaged in any site-specific discussion about the project's impacts to bull trout. Rather, the BLM unilaterally determined that there would be no effects because it incorrectly found that bull trout were not present in the action area, and that is in the BA at Fish and Wildlife Service record 170. And bull trout are not mentioned in the Fish and Wildlife Service record beyond that one sentence in the BA, and then again on the cover letter of the biological opinion, which does not include a concurrence specific to bull trout, and that is Fish and Wildlife Service, page 31. Because there is no concurrence letter in the record specific to bull trout, and there are no emails or any other evidence or supporting documents related to bull trout in the Fish and Wildlife Service record, there is no indication that any Fish and Wildlife Service employee ever considered this issue. And that failure to get a written concurrence from the Fish and Wildlife Service, which is the expert agency on bull trout, is a violation of the ESA. And defendants make 3 arguments in response to this issue. The court should emphatically reject each one. First, defendants argue that the agencies adequately considered the effects to bull trout in their programmatic consultation for the Missoula RMP. And that is not true. The RMP biological opinion does not replace site-specific consultation. The RMP biological opinion discusses general effects from timber harvest and road building, but there is nothing site-specific, which is why the biological opinion itself requires site-specific consultation at the project level. And that is in the record at BLM 5788. Thus, defendants' tiering argument fails. Alternatively, defendants claim that the BLM did conduct a site-specific analysis for the project, just not in the form of a biological assessment. However, this approach has been squarely rejected by this circuit. In Friends of the Clearwater v. Petrick, the court found that a no effect determination in a wildlife report does not excuse the action agency from preparing a biological assessment. And the citation to that case is 588 F sup 3rd at 1086 to 1087. And likewise, in Native Ecosystems Council v. Martin, this court held that a site-specific analysis in the environmental assessment, while tailored to the project, does not fulfill the agency's consultation obligations because it did not receive Fish and Wildlife Service concurrence. And that citation is 612 F sup 3rd at 1161. And that is the same situation that we have here. Finally, defendants' argument that the BLM's no effect determination is reasonable and independently supported by the record is unavailing. Defendants rely exclusively on Alliance for the Wild Rockies v. Savage for this point, and Savage is an opposite. In Savage, it was a question of whether bull trout were even in the project area, whether they were even present, and whereas here, it's undisputed that bull trout and bull trout critical habitat are present in this project area. Yet the project authorizes logging, burning, and timber hauling in units that are on the banks of the Clark Fork River and along Bear Creek, which flows directly into the Clark Fork, as well as the headwaters of Union Creek, which is a tributary of the Blackfoot. And that is available, the map showing those rivers and those bull trout streams is at BLM 2554. Thus, the record does not support the BLM's determination that the project will have no effect on bull trout and bull trout critical habitat. But critically, at the BLM's failure to consult either formally or informally on bull trout is a violation of the Endangered Species Act. And moving on to the lynx issues. First, in plaintiff's view, the BLM's approach to Canada lynx management is superficial, bordering on disingenuous, and it fails to conserve lynx. The Garnet Range is designated lynx critical habitat, and the garnets provide critical habitat for the southernmost lynx population in western Montana. The BLM has promised to contribute to the conservation and the recovery of lynx through the Lynx Conservation Assessment and Strategy, which I will refer to as the LCAS. And that was incorporated into the Missoula RMP through Wildlife Objective 1. That means that lynx conservation measures in the LCAS are mandatory under the RMP. And those standards and conservation measures are in the record beginning at Fish and Wildlife Service 5479. Yet the BLM designed this project to bypass nearly all of the LCAS's conservation measures under that document's exemption for projects occurring within the wildland-urban interface, or WUI. And now the first thing to note is that in the RMP, the BLM greatly expanded this WUI exemption to include all of the WUI and also something that it calls Fire Management Zone 1, or FMZ1. And at the project level, the BLM even added in some additional lands in Fire Management Zone 2 to form the project's, quote, functional WUI. And plaintiff's RMP claim stems from the fact that the LCAS never contemplated such an expansive WUI, and neither the RMP nor the project consultation documents take a hard look at the impacts to lynx from that significant expansion, which in effect allows the LCAS's limited exemptions to swallow the rule. And this is especially important as applied to this project because the BLM is exempting all but about 240 or 250 or so acres of lynx critical habitat from complying with the LCAS's conservation measures under the project's functional WUI. And this brings me to plaintiff's second and third lynx claims. The plaintiffs challenge the agency's conclusions that because the project will affect less than the total allowable acres under the RMP's incidental take statement, that the impacts to lynx will be insignificant. Plaintiffs argue that this total acres approach fails to take a hard look at the actual impacts to lynx under NEPA and under the ESA it fails to consider the best available science and relevant factors which are discussed at length in the LCAS and are mandatory under the RMP. Therefore, the Fish and Wildlife Service's conclusion that the project will not jeopardize lynx or adversely modify designated lynx critical habitat is arbitrary and capricious. And I would like to discuss this issue a bit more with a visual aid, which is a map from the biological assessment at Fish and Wildlife Service 166. May I approach, Your Honor?
You may. Yeah. Actually, it's up. Okay.
So first, defendants do not dispute that the LCAS is considered the best available science on lynx. And as explained in the record at Fish and Wildlife Service 5476 and 5477, the LCAS generally requires that lynx habitat is analyzed at the level of 1 lynx analysis unit, or LAU, not 4. And that is because each LAU must have sufficient habitat to support a single lynx. And LAU boundaries are not adjusted for individual projects, but must remain constant to be effective for their intended purposes of planning and monitoring. In some cases, the LCAS acknowledges that project impacts may need to be assessed across 2 or more LAUs in order to, quote, fully address direct, indirect, and cumulative impacts of particular actions, end quote. But, Your Honor, this statement is intended to capture impacts that occur on a larger landscape scale, like wildfires, which the LCAS says may create change across many adjoining LAUs. It is not an excuse to dilute the impacts of a federal action's effects on lynx within any single LAU, which is what the agencies did here. So if you look at this project map closely, the tiny slivers, first, just for the record, this green area is called the Elk Creek LAU. This is the Union Creek LAU, Bear Creek, and McElwain Creek. So in this project, you can see that most of the project area is these bottom 2 LAUs. And the tiny slivers of Elk Creek, somewhere in this area, and McElwain Creek, so those are included within the project area boundaries, but what I'd like to point out is that those LAUs hardly include any BLM land. And not only that, but the project documents at the supplemental biological assessment states that only 15 acres of the 4,287 acres of lynx habitat in the McElwain Creek LAU are even implicated by the project. And conversely, the project will leave only 40 acres of lynx habitat untouched in the entire Union Creek LAU. And those numbers are available in the supplemental biological assessment at Fish and Wildlife Service 138. So in effect, the agencies expanded the project's analysis area for lynx to encompass 2 additional LAUs that contain significant lynx habitat, thus padding the numbers and superficially dismissing any potentially significant impacts to lynx within the 2 LAUs that make up the vast majority of the project area. And because pulling these additional LAUs drastically dilutes the project's effects in a way that is arbitrary and capricious, the analyses are invalid under both the ESA and NEPA, and the agencies are not entitled to deference for that arbitrary and capricious decision-making because they fail to offer any explanation or any acknowledgement that this is what they've done. And a good citation for that is Center for Biological Diversity v. Zinke, 900 F. 3rd at 1067. And next, because lynx habitat is complex, the LCIS instructs that both the abundance and the juxtaposition of lynx habitat are relevant factors in analyzing impacts to lynx. But the agencies here only considered the abundance and not the juxtaposition of lynx habitat across all 4 LAUs. And only looking at the percentages of affected lynx habitat across all 4 LAUs combined is especially deceptive in this case because the overwhelming majority of available lynx habitat is outside of the project area, and nowhere do the agencies acknowledge that nearly all lynx habitat within the project area will be affected by this project for the next several decades. And when you consider the location of the affected habitat, it becomes clear that this project substantially shrinks the available lynx habitat into a smaller portion of the garnets, and it does so behind a smokescreen of meaningless percentages in the biological assessment. So despite this obvious flaw, the agencies offer a litany of unsupported conclusory statements. For example, in the biological opinion, the Fish and Wildlife Service concluded that the project complies with LCAS guidelines to first, leave substantial areas of lynx habitat untreated, second, retain patches of dense horizontal cover, and third, not to remove more than 15% of the horizontal cover in lynx habitat on federal lands within a single LAU within a 10-year period. But there is nothing in the record to support any part of this statement, and the statement is in the record at Fish and Wildlife Service, page 33. So first, any substantial areas of untreated lynx habitat are entirely within the 2 LAUs that are outside of the project area. And second, treatments will only retain patches of dense horizontal cover in Fire Management Zone 2, which is a very small percentage of the lands in the project area. And the Kerry Declaration, which was submitted as a part of the preliminary injunction briefing in this case, confirms that variable density thinning techniques will only be used in lynx habitat that is outside of FMZ1 and the WUI, which again, in this project area is minimal to non-existent. And that is document 38-1 at paragraph 20. And even this technique does not retain dense horizontal cover, as you can see at BLM 226, 227, and 235, which are photos in the environmental assessment that purport to show what variable density thinning techniques will result in. And so third, the BLM made no attempt to comply with the 15% horizontal cover standard because treatments in lynx habitat were green-lighted under the RMP's WUI and FMZ1 exemption. So in sum, this project undermines the science by effectively pushing lynx out of the project area rather than conserving the remaining critical habitat within it. Your Honor, I'd like to turn now to grizzly bears and Project Haul roads. As this court is well aware, roads likely pose the most imminent threat to grizzly bear habitat today, and the management of roads is one of the most powerful tools available to balance the needs of people with the needs of grizzly bears. And this issue is paramount in this case because we know that the project area currently provides important connectivity habitat for dispersing grizzly bears, which are essential to the recovery and the long-term viability of the species. Those of us lucky enough to live in Missoula have become accustomed to the news that an adventurous grizzly has wandered out of the NCDE and into the Rattlesnake or into the Sapphires or the John Long Mountains in search of a new home, maybe in the Bitterroots or beyond. And often those bears are finding essential refuge in the Garnets. Plaintiffs allege 3 violations involving Project Haul roads and grizzly bears. First, the project's temporary road construction results in a clear violation of the Missoula RMP biological opinion's second surrogate measure of incidental take. Second, the project violates the Missoula RMP biological opinion's first surrogate measure of incidental take by adding nearly 20 miles of open roads to the BLM system without reinitiating consultation on those roads. And third, the project's biological opinion is arbitrary and capricious because it entirely fails to consider the current condition of project roads, which is a relevant factor. And the second surrogate measure of incidental take issue is straightforward, so I'll start with that one. Under the ESA, reinitiation of formal consultation is required if the amount or extent of taking specified in the incidental take statement is exceeded. And here, the BLM admits that the ITS has been exceeded. The biological assessment states the proposed construction of temporary roads would surpass the amount allowed for a 10-year period under the Missoula Field Office RMP biological opinion in NCDE Zone 2, with 4.09 miles proposed versus 2.0 miles allowed. And the site to the BA is Fish and Wildlife Service 190, and the RMP ITS is in the record at Fish and Wildlife Service 293. Therefore, reinitiation of consultation is required. Now, in response to this claim, defendants argue that because only 0.33 miles of the project's total 6.24 miles of temporary roads would be constructed in secure habitat, only 0.33 miles would adversely affect grizzly bears, and only 0.18 miles of those new temporary roads should be counted against the allowable take in Zone 2. And that argument is flawed because the RMP's incidental take statement does not limit the second surrogate measure of take to only temporary roads constructed in secure habitat. The ITS limits the construction of temporary roads across all of Zone 2. Further, defendants are not entitled to deference in their interpretation of the RMP ITS as applying only to temporary roads constructed in secure habitat because the plain language of the ITS is not ambiguous. Its terms are clear, and the court must enforce the plain terms of the take statement. And plain and simple, the regulations require reinitiation of consultation when a take statement has been exceeded, and that is what happened here. And I'm now going to discuss plaintiffs' claim that the agencies failed to provide a detailed discussion of the effects of the project because they failed to consider the current condition of project haul roads, which is an important factor. And it is an important factor because under the Endangered Species Act, the agencies are required to establish baseline road densities, and that baseline becomes the foundation of their effects analysis or analyses. And so my discussion on that issue will dovetail into plaintiff's claim regarding the project's violation of the RMP's first surrogate measure of incidental take for grizzly bears. And I want to start off by acknowledging that defendants take issue with plaintiff's use of the term impassable roads. Defendants argue that plaintiffs have unilaterally designated roads as impassable despite the agency's assurances that the project has no effect on motorized designations for existing roads. They argue that the condition of the road is immaterial. It is only the agency's official travel management designation that matters, quote, regardless of the actual conditions on the ground. And that's in Doc 28, page 14 and 15. And, Your Honor, defendants are wrong. Plaintiffs use the term impassable because that is the term that the applicable management documents use to describe old roads that for one reason or another do not function as open roads. And defendants call these existing roads or they call them legacy roads, but neither of those terms are defined. We don't know what those terms mean. What we do know is that the Missoula RMP at BLM 597 and the NCDE Conservation Strategy at Fish and Wildlife Service 1522 define impassable roads, which may become impassable for a variety of reasons, including natural vegetation growth, road entrance obliteration, fallen trees, boulders, etc. The Conservation Strategy at Fish and Wildlife Service 1651 explains that turning an impassable road into an open road has an on-the-ground effect to grizzly bears, which is why the biological opinion at Fish and Wildlife Service 228 specifies that a road's adverse effects can vary depending on the existing condition of that road. Therefore, to properly analyze a project's effects, the existing condition of the roads must be considered, and it was not here.
Okay, Ms. Bronston, I'm having trouble with the roads, trying to figure this out. So are these 19 miles of newly discovered, we'll call them undetermined roads, are these the same roads that are represented in the photographs attached to the Ackland Declaration?
Your Honor, no, not expressly. The Ackland Declaration includes 3 photographs. I don't actually have it in front of me, but I know for a fact that our intention with that is not to show existing roads only, it is just to show the condition of project haul roads generally. So for example, can you bring it up so I can? There is one image in there which shows a giant Kelly hump, so a big old berm with some boulders, and that road is actually an open road according to the project map. That is not an existing road according to the project map. There are other roads that are existing roads. I think we did include a picture of an existing road that was also very closed in and overgrown. The declaration shows that, in general, the condition of project roads was not considered.
Okay, so let's just hold on for a second here.
Annie?
So with respect to the first surrogate incidental take argument, is it your position that because these 19 miles of undetermined roads are currently impassable and will need to be altered in some way to serve as haul roads, that this on-the-ground change will increase open motorized road density and result in a surrogate take? I mean, is that the position boiled down in its simplest essence?
That is a component of the position. I think it is a complicated claim here because we have our claim about the condition of the roads in the project area actually extends beyond these existing roads, but we actually have that number 19.35. So that is, those 19.35 miles of roads are not, there's no discussion about the condition of those roads. So you have to assume that they are going to be altered from their current condition into a haul road that meets the best management practices standards.
Okay, so you said we have to assume that these roads are going to be converted into haul roads. Why do we assume that?
Well, we assume that they're going to be converted into haul roads because that's what the project authorizes.
Okay.
Now,
so, and where is, can you point to me where in the record that is authorized?
Well,
Maybe you can look when you, before you do
Yes.
your rebuttal.
I will find you a site for that. I would say the place that is authorized is in the decision notice because the decision notice authorizes the addition of these 19.35 miles to the BLM system. And the Marks Declaration, Kathleen Marks Declaration, which was attached to the preliminary injunction briefing, Kathleen Marks specifies that the purpose of adding those roads to the BLM system is to make them drivable, maintained, open roads. And she, in paragraph 8, specifically says those roads will be maintained as public, open, accessible roads. Okay,
so the RMP defines an open road as any road available for year-round public use. And open motorized road density as roads and motorized trails that are open to wheeled motor vehicle use by the public for any part of the non-denning season. it seems to me that these 19 miles of roads that BLM recently discovered are closed to public use. So how then does the addition of these roads alter existing road density?
There's no indication in the record that those roads will be closed to public use after the project turns them into open roads. I agree with Your Honor in the sense that currently, right now, today, these are closed roads.
Right,
And they're closed because you can't drive on them.
right,
And that's the definition. There's not really any ambiguity on that.
right.
So once the project, because the project has authorized these roads to be utilized as project roads, as haul roads, we know that the standards that those roads have to be at are pretty much full-on, drivable, very wide roads. And there is, in the briefing, we have a pull-out quote here from the biological, or from the EA. Sorry, just take a minute to find it. But it's a significant amount of work that goes into making those roads drivable. They have to be bladed and shaped. The road surface is completely altered. A stabilization and augmentation of the road surface as needed by gravel and dust abatement. There's replacement of drainage features. They have to be cut and filled to plus 5 feet to maintain a sight distance for traveling, for vehicle safety. So all of the actions that are going to occur in order for the BLM to utilize these roads as part of this project, that fits squarely within the definition in the conservation strategy of the actions that would change this, that would make an on-the-ground change. And so that is the core of our argument, is that those roads, both existing roads that are purple hashed lines on the map, and some of the actually designated open roads in the project area are going to require significant road work. But nothing in the project actually delineates how many miles of roads are going to require that kind of maintenance, or how many miles of roads are currently drivable versus how many miles of roads will currently be drivable after the project. And that is, by definition, the definition of open roads. So every logging project Your Honor probably has ever seen is going to have some level of road maintenance, and some of those, designations are they're there for a reason. And here there's no delineating any sort of level of road work, and especially because even in the record it acknowledges there are lots of legacy roads out on this landscape, and the BLM hasn't maintained them all to the standards that would make them currently open roads.
Can you identify in the record the best map that we have that shows all of these roads?
Yes. I can get you that site, Your Honor. I thought I might be able to find it.
Yeah, if
but
you would do that when
Yes.
The government's arguing. Thank you.
Yes. And so, just to kind of finish up that important factor discussion, it's just the fact that there's no information in the administrative record as to the current state of project haul roads, or how many miles of these authorized haul roads will require reconstruction. And that is enough for plaintiffs to succeed on this claim, because that is an important factor under the management documents in an analysis regarding grizzly bears. And by falsely assuming that all project haul roads can sustain motorized access right now, the agencies have failed to consider the effects to grizzly bears from turning old roads not currently functioning as roads into haul roads. And, just to bridge into the first surrogate measure of take argument, Table 4 in the Missoula RMP biological opinion, so that is at Fish and Wildlife Service 292. It provides a table, and that table is the incidental take statement for this area. And the lands in the Missoula field office were divided into 5 distinct geographic areas, which created the take statement. And this project only area at issue is the Garnett-Chamberlain area. So Table 4 specifies that if the amount of open motorized road miles exceeds 240 linear miles, or 2.0 miles per square mile in the Garnett-Chamberlain geographic area, then the level of permitted incidental take would be exceeded. So, other than one conclusory statement that the project will not increase open roads because it does not authorize any new permanent road construction, there is no evidence in the record that the project complies with the first measure of incidental take. However, there is ample evidence in the record that the take statement has been exceeded. And that is because, as Your Honor mentioned, turning these 19.35 miles of old roads or undetermined roads or legacy roads or existing roads into haul routes by adding them and then adding them officially to the BLM system increases the open and total linear road miles in the Garnett-Chamberlain geographic area. And that would exceed the amount of take authorized by the RMP biological opinions incidental take statement. And defendants take a scattershot approach to defending this claim, and they are wrong that all 19.35 miles of existing roads will be closed. The declaration of Kathleen Marks, as we discussed, makes clear that existing legacy roads will be reconstructed to BMP standards, and then they will be funded and maintained as fully open roads going forward. And that is document 38-3 at paragraph 8. And that is also why defendants are wrong when they say that only total roads are at issue in this case. And although site-specific consultation on the project did occur regarding the draft environmental assessment's proposal to build 15 miles of new permanent roads, that is not a cut and paste analysis because these existing roads will be added as open roads and those proposed permanent roads would have been closed to administrative use only. And that is at Fish and Wildlife Service 8, page 83. And defendants also argue that road density calculations and maps in the project consultation documents included these roads. And again, there's absolutely no evidence in the record to support that claim. First of all, that explanation, whether they do or do not include these roads, would have to be in the biological opinion itself, can't be buried in a 20,000-page administrative record. And defendants cite to BLM 2774, which are tables in the BLM's administrative record that list mapped roads by NCDE zones. But critically, those tables do not isolate the Garnett-Chamberlain geographic area, which is the appropriate geographic scope of the take statement. So the other argument that defendants made at the preliminary injunction hearing is they argued that BLM 2712 through 2768 show that the BLM did a mileage update in 2021, and quote, that's how we know that 13.75 miles of that 13.35 miles was already mapped. And counsel's post hoc explanation begins in the preliminary injunction hearing transcript at page 48, line 17. Counsel told the court that this was a list of every single road in BLM's inventory for the RMP planning area, so that would be the entirety of the full lands under the authority of the Missoula Field Office for BLM. But again, Your Honor, the Missoula Field Office is not the scope of the incidental take statement for grizzly bears. And the table tells us nothing relevant to this claim. The question in this case is whether the project will exceed the incidental take statement's 240 miles of open roads or 390.4 miles of total roads within the Garnett-Chamberlain geographic area, not the entire Missoula Field Office and not even NCDE zones. So defendant's math simply does not add up by any stretch of the imagination, and because there will be on-the-ground changes, that needed to be, the condition of the road needed to be considered, and the specific mileage of those reconstructed roads needed to be disclosed. And finally, Plaintiffs challenge the cumulative effects analyses in the project environmental assessment, the biological assessment, and the biological opinions. It is undisputed that logging, thinning, and burning, as well as road building, will adversely affect grizzly bears and lynx, as well as other wildlife. Yet, despite known, comprehensive, and widespread efforts by all landowners to significantly alter the current composition of the forest, the agencies broadly conclude that cumulative effects to wildlife from these activities will be insignificant. But because their analyses lack important, detailed information about all of the reasonably foreseeable actions that will be taking place over the next 3 decades, the agency's conclusions are arbitrary and capricious in violation of NEPA and the ESA. And second, the Fish and Wildlife Service's analysis is further lacking because the biological opinions identify distinct analysis areas for grizzly bears and for lynx that are significantly larger than the project area, yet no additionally reasonably foreseeable actions were disclosed or discussed. And under the ESA, the Fish and Wildlife Service has a duty to seek out and consider all of the relevant information that would inform their analysis. But because that was not done here, the biological opinions for grizzly bears and lynx are inadequate under the ESA. And defendants' primary argument on this issue is asking for deference to the BLM's analysis because of the Supreme Court's recent decision in 7 County Infrastructure v. Eagle County, Colorado. But, Your Honor, this issue does not implicate agency deference. As the court noted in Alliance for the Wild Rockies v. Probert, defendants can argue that the existing analysis is sufficient, and that proposition is either correct or incorrect based on the factual record. And second, 7 County is inapplicable because plaintiffs are not asking the court to consider separate projects and their attenuated environmental effects. At issue here are the effects of the Clark Fork Face project when combined with the effects of similar types of projects by other landowners occurring within the project analysis area and during the same time frame as this federal project. Your Honor, unless there are any questions, I would like to reserve the rest of my time for rebuttal.
All right, well, you're right at 41 minutes anyway, so you'll have 5 minutes for rebuttal.
Thank you, Your
Thank
Honor.
you. Ms. Polachek.
Thank you, Your Honor. Sorry, Your Honor, I have a lot of papers here. Your Honor, I will be starting by talking about the Endangered Species Act claims that plaintiffs have brought, and then Mr. Duffy is going to take over and talk about NEPA and address any questions that the court has with respect to FLTMA claims as well. And I think that there are 2 things that I'd like to say at the beginning to make sure that we're oriented to what's happening on the ground here. And the first is that the court is very familiar with these forest projects. The thing that makes this one different, there are 2 aspects to it. The first is that the land itself is different than many of the projects that come before the court, and that's a result of the historic uses of this land, going back to the mining and the timber sales, and that the fact that the timber companies are now selling off this land to private owners who have built structures, including homes, in this area. And the second is the fact that this is a BLM project instead of, we usually see these as Forest Service projects. And that manifests in 2 ways. First is that BLM land is much more checkerboard-like than, say, a full national forest that is under Forest Service control. And so that means that the BLM is working with a lot of these, again, private landowners, as well as county and state land holders. And the other way that this manifests is that it's important to keep in mind that we need to use BLM terminology when we're talking about this case. I think that it's probably right to just jump in with roads because, and that's where we're seeing some misuse of terminology. Plaintiffs continuously use the term open roads. That is a defined term under BLM and under their RMP. Open does not mean passable. Open means that it is open for public use. So BLM has open roads that are open for the public to use, and then they have limited roads, which are roads that are available only for BLM to use for administrative purposes. That's what the haul routes are going to be. And then they have closed roads that are not open for any purpose whatsoever. In this case, no roads that are currently either limited, meaning they're open only for BLM to use, or closed are becoming open roads. There is no change to the motorized status of any road in the system. With respect to this, I think that the plaintiffs, I understand that they're making an argument with respect to the 19.3 miles of roads that were added to the FAMS database. And then they're also making an argument that there is some unknown number of roads that they claim are currently impassable. To the extent that those overlap, it's not in their briefing. I want to kind of do a background about the roads, and then we're going to come back to this issue of impassable, because I do think it's important to keep in mind there's absolutely no evidence in the record that any of these roads are impassable. The only thing we're looking at is a declaration submitted by plaintiffs' counsel 2 years after the project was finalized, and that has been now rebutted by a BLM employee, Mr. Fothergill, in the PI briefing, where he pointed out that the pictures that were taken are not actually BLM roads. They're looking at an adjacent trail, or they're looking at the terminus of a road and claiming that it's impassable. So there is no evidence in the record that any of these roads at all are impassable. But let's talk a little bit about the 19.35 miles. So the first thing that's important to keep in mind is that there's a difference between the FAMS database, the facilities and management system, and like travel maps and inventoried roads. The FAMS database is really more of an internal database for BLM to keep, and they use it mostly for budgetary reasons. It's to keep track of the facilities that they have and to make sure that they're getting the proper funding for those facilities. It's not a public-facing system necessarily, as opposed to inventoried roads and travel maps and travel designations. That is very much public-facing, and that is what determines whether a road is open, limited, or closed. It's the map and the travel designation. Again, nothing in this project is changing any travel designation at all. In fact, if BLM wanted to change travel designations, it would have to do NEPA. The RMP says it must do NEPA in order to change the designation of a road. And it hasn't done that because it's not changing the designations of any roads here. So with those 19.35 miles, that's the mileage that BLM, when they were out scoping for this project, discovered was not in their internal asset management system in the FAMS database. Has nothing to do with whether these roads were mapped or inventoried. You can tell whether, so then taking those 19.35 miles, BLM took them back, and they had done in 2021, as plaintiffs' counsel quoted me saying, they had done an update of the roads in 2021. And every single road in the RMP, the Missoula Field office area, is listed by number and their mileage at BLM 2712 to 2768. Every single road is listed there. And why that's important is that we can go back and look, and we can see that of those 19.35 miles, that there is more than 13 miles were already included in the inventory, the forward-facing, the public-facing mapping document, which means that those roads had a travel designation already, and they were all either closed or limited. None of those roads were open, meaning they're not open to the public. Not that they're not passable, they're not open to the public. That's what that means. So there's 5.6 miles then that were not in that map. And so, okay, So 5.6 miles were not included in the map. And the reason that that's important is that that 2021 road update, that's what was used when the RMP looked at the different grizzly geographic areas, and that's where we get the Garnett-Chamberlain area that we're looking at here. Each of those 5 grizzly areas, geographic areas, has a linear road mileage associated with it. For the Garnett area, that's 374.8 miles. So that 2021 road update with all that mileage, that's the basis for determining that there are 374.8 linear miles of road in the Garnett geographic area. And so that includes the 13 miles that were already in that update. There are 5.6 miles that were not in that update that are not included in that 374.8 total linear miles of road. And again, we're looking at the total linear miles because open motorized road density does not mean passable road density. It means open to the public motorized road density. This project has nothing to do with open to the public roads. We're not changing that in any way. None of the 19.35 miles are open to the public. So we're not looking at open motorized road density as that term is defined by BLM. So for the total linear road density, we know that Garnett has 374.8 miles that was accounted for in the RMP. We add the 5.6, and then we divide that. That's our total linear miles. We divide it by the area of the Garnett region, the 122 square miles, and it is still 3.1. It's 3.118 miles per square mile. And we round that, according to the RMP, we round that to the nearest tenth. So it's still 3.1 miles. So the total linear road density is not changing by adding in those 5.6 miles. Now that's one of the arguments to explain why incidental take for the first surrogate measure has not been exceeded. The other reason, though, is that the RMP ITS, I direct the court specifically to FWS 292. It's very important. That's where we have the take statements listed. But the paragraph above that table is also important because it explicitly says that, that the Fish and Wildlife Service considered that there would be mapping errors that would occur with this mileage, and that was incorporated into the road density that was allowed in the incidental take statement. And essentially what that means is that a mapping error is not incidental take. So at the very beginning, the fact that what we're dealing with here is a mapping error and not on-the-ground activities. We're not making any roads that we're not making any new open roads. It's just roads that are already there that are available for limited use or they're closed. That's it, and they're not changing. And so the fact that that's happening, that these roads have been discovered and that they're being added to this internal database, that is not a triggering event for the incidental take statement at all. But even if it were, we're still at 3.1 miles. And in fact, we could go up to 3.2 because in the course of this project, Fish and Wildlife considered the impact of going up to a 3.2 miles per square mile road density because there was originally assumed that there would be permanent roads added. So in fact, the Fish and Wildlife Service has already considered and included in the incidental take statement up to 3.2 miles per square mile, which represents approximately 20 miles of roads that could be added to this system without changing the road density in a way that would violate the incidental take statement. So that deals with the 19.35 mile argument of roads, I think, unless the court has any further questions. Nope. Okay. So then looking at the impassable roads, again, this is based on this declaration that Mr. Fothergill in the PI stage pointed out is actually incorrect. It's an incorrect assumption of what's going on the ground. So there's nothing in the record that suggests that there are impassable roads to begin with. But even if there were.
Can I consider the Ackland Declaration?
No, Your Honor. It is extra record. It was done 2 years after this project was authorized, and as shown in our rebuttal declaration, it's incorrect. It's interpreting the maps incorrectly. But I would point out to Your Honor that even if there were impassable roads, the point is that in the RMP BIOP and then the second tier project BIOP, Fish and Wildlife did consider the effects on grizzlies of these roads having cars going across them. So even if the court remanded, the analysis is already there. It's unclear what the agency would do other than point to the analysis already done and say, well, we thought these roads were passable, and we said that these are the effects of these roads being used by cars. So that's our analysis. It's right there. And so then the last roads argument regards the temporary roads. And so specifically, the temporary roads that are in NCDE Zone 2. And so the incidental take statement for temporary roads says that you can't exceed 2 miles within 10 years. And in this case, there are going to be more than 4 miles of temporary roads constructed in the project area. But the important thing that the RMP BIOP explains is that not all roads result in adverse effects, let alone even take. Take only occurs if bears are actually using the area. And that's something that, again, because of the nature of this area, is just not very common. And the reason we know that is that we measure the bear's use of the area and bear habitat using secure habitat. And secure habitat is this habitat that is, at least 500 meters from a road. And there just isn't much of it in this project area, let alone in the Garnett-Chamberlain geographic area in total. So we know that to the extent that bears are using the area, they're mostly using and relying on the secure habitat. So that's the important place to look to determine whether or not the roads are going to affect the bears, is where is their secure habitat? Where are the roads infringing upon that secure habitat? And that's why the biologist in the site-specific BIOP went through a great deal of analysis of the type of roads, describing the temporary roads in this case. And she noted that it's not just the mileage, it's the location and duration of the roads. And she pointed out that the majority of the areas where these temporary roads are going to be built are in existed roaded areas. In fact, most of them are being added as little spur roads at the end of existing roads. Also, these segments that are being added as these little spurs are very short. In average, it's 0.1 mile, or about 160 meters total, that's being added. And the other point is that the roads are going onto the landscape for a very short duration. It'll be no more than 36 months, and then they will be obliterated. And they're also not going to be built at once, as the biologist explained. That means that it's possible that there will be no more than 2 miles of temporary roads on the landscape at any given time. And the biologist pointed out that the best scientific evidence available is that focuses on secure core habitat. And that's why she found that only 0.18 miles of temporary roads in Zone 2 are actually going to infringe upon that secure habitat, saying that that's where the take is most likely to occur, if it will occur at all, is in that 0.18 miles of roads. And that falls under the 2 miles in the incidental take statement. And I'd point out, plaintiffs talk about deference, but I think what we're talking about here is deference in more of a common sense way. And that is the fact that this is the same biologist who wrote both of these BIOPs. So this is the biologist who knows what was authorized in the RMP BIOP. because she is the person who wrote it. I'd also point out, I point the court to Bradford, which is at 720 F sub second at 1213. And there Judge Malloy was looking at the impacts of roads on grizzlies and pointed out that in that case, which had more roads, both permanent and temporary, being built, said that it was a close call, but because the agencies had done a close look and provided reasons for their conclusions, it was necessary, and this is a quote, it was necessary to defer to their decision. And that's the same thing here. The biologist is given reasons why the proper number to consider under that 2 mile incidental take statement is 0.18 miles. And this court, because she's explained exactly why and why the impacts on the grizzlies will only occur in those areas that does deserve the court's deference. Does the court have any other further questions on grizzlies?
Or roads? No.
Thank you, Your Honor. I'd like to briefly touch on bull trout and lynx, and then Mr. Duffy will also address the lynx as it relates to the NEPA claims. With respect to bull trout, the important thing to keep in mind is that there was a biop done in this case. It was just done at the programmatic level. And that's different than the cases that the plaintiffs are citing. It makes this case unique because what happened here was that the RMP was developed and the biop said, all of these management objectives, these design features that you're adopting in this RMP, if these are all followed, then it's not likely to adversely affect bull trout. And so and in fact it said that following the riparian management objectives, the RMOs, that were established in those design features would either maintain or benefit bull trout and bull trout critical habitat. And so what the agency did here was it implemented every single design feature necessary for riparian areas, and then it said that because we're following those RMOs, the RMP and the RMP biop has said that it will maintain or improve bull trout and bull trout critical habitat, and therefore there will be no effect on bull trout. The other thing to keep in mind is that there is quite a bit of explanation as to why this is the case. The main concerns with bull trout are sedimentation and affecting bull trout habitat. But that's not an issue here, and thus will not affect bull trout because, first of all, there is nothing happening on the banks of bull trout critical habitat or in bull trout critical habitat because there's a 300-foot buffer zone for bull trout critical habitat. That's a full football field away from the critical habitat. And then secondly, the location of what's happening is very important because any sedimentation that is likely to occur is not, it's miles away from the bull trout critical habitat and its tributaries. And we know that sedimentation has very localized effects. And in fact, within 800 meters of action, we see that sedimentation is no longer an issue. So if we're miles away, then we're well outside that area. The other thing is that sedimentation for bull trout is really only an issue in its spawning and rearing habitat. And here, the Clark Fork and Blackfoot rivers provide only foraging, migration, and overwintering habitat, not the type that is adversely affected by sedimentation. And that's a BLM 306. So for those reasons, the agency's actions with respect to bull trout were proper. I'd also note that because we're miles away from these tributaries, at this point, the agency is aware of only one project that is likely to impact riparian areas or to impact bull trout critical habitat, and that's at least 5 years away, which is, obviously some time from now. And then going on to lynx, unless the court has further questions about bull trout. So I think the important thing to keep in mind here is that LAUs are the appropriate measure for determining the effects on lynx. I think everyone agrees on that. And moreover, the agency was required to use LAUs and to address the effects in each affected LAU here, which it does include 4 different LAUs. And while the agency did talk about the total amount of lynx habitat across the LAUs, and again, we're talking about that the total amount is over 4,000 acres, and this project's going to affect 243 acres. It also broke down the impacts on each LAU by LAU, and I direct the court to FWS 138 for a discussion of what's happening in each LAU. And those tables at FWS 138 certainly support the conclusion in the BIOP that these effects are being spread out across multiple LAUs, with 20% of treatments occurring in Bear Creek, about 5% in Elk Creek, about less than 1% in McElwain, and 55% in Union Creek. And again, it's also important to keep in mind that treatment doesn't necessarily mean the destruction of lynx habitat. Where the agency is able to, outside of the WUI, as detailed in our brief, they're taking measures to make sure that the horizontal cover is maintained. And then Mr. Duffy will talk about the WUI and how that relates to lynx. Unless Your Honor has any further questions, I think that's all I wanted to.
Did you want to reserve some time for review?
Yes, Your Honor.
How much? You're at 33 minutes.
Okay. I think we'd like to reserve 5, 4.
Yes, Your Honor, I've been keeping time as well, and I don't know if I'm doing it right, but we're at 24 minutes on my stuff.
Really? You are correct. I misread it. It is 24 minutes and 16 seconds.
Sounds right.
19 seconds now. All right, so you want to reserve, again, 10 minutes for rebuttal?
I think we'll do 5 minutes.
Okay.
Mr. Duffy will talk for 10. Thank you.
Good afternoon, Your Honor. As Ms. Polachek mentioned, I'm going to discuss the NEPA claims and the FLIPMA claim. I know plaintiffs didn't address the FLIPMA claim, and I'm only going to address that briefly at the end. Okay. So as Your Honor is aware from our reply briefing, the Supreme Court has recently affirmed that the bedrock principle of judicial review under NEPA is deference, and that's the 7-county infrastructure coalition case. And it's instructed courts to afford substantial deference to agency choices as long as they fall within a broad zone of reasonableness. Thus, the court has a limited role in reviewing the sufficiency of the agency's consideration of environmental factors when the agency undertakes a project. Plaintiffs argue that BLM violated NEPA in 2 ways. First, they claim that BLM failed to take a hard look at project impacts on Canada lynx and lynx critical habitat. Second, they claim that BLM failed to meaningfully consider the cumulative impacts from other state and county projects. I'm going to start with the hard look claim in a moment, but I first want to discuss 7-county in a little bit more detail. I believe that 7-county case provides some important direction to courts in how to analyze challenges under NEPA. Specifically, the courts, I'm paraphrasing from the case, but the court in 7-county said that when assessing significant environmental effects for purposes of NEPA, an agency will invariably make a series of fact-dependent, context-specific, and policy-laden choices about the depth and breadth of its inquiry, and also about the length, content, and level of detail of the resulting environmental analysis. Courts should afford substantial deference and should not micromanage those agency choices so long as they fall within that broad zone of reasonableness. Speaking to judicial review generally, the court noted that NEPA has been transformed from a modest procedural requirement into a blunt tool to stop or slow government projects. As such, the court noted that a course correction is appropriate to bring judicial review under NEPA back in line with the statutory text. This is not included in our briefing, but as I was preparing yesterday, I decided to look and see if the Ninth Circuit has had anything to say about Seven County. And indeed it has. The Ninth Circuit reiterated the Supreme Court's guidance regarding the need for substantial deference and instructions not to micromanage agency choices, so long as they fall within that broad zone of reasonableness. And that case is Cascadia Wildlands versus BLM, and it's on Westlaw, 2025 Westlaw 2460946. It also extended Seven County from the context of an EIS, as was the case in Seven County, to the EA context, as was the case in Cascadia Wildlands and is the case here. Let me turn to the hard look analysis. The project EA shows that BLM analyzed project impacts to lynx and lynx critical habitat in detail. Treatments within the WUI and Fire Management Zone 1, BLM states are the highest priority and take precedence over other resources on BLM-administered lands, and that's at BLM 54. The environmental assessment incorporated by reference the consultation documents that were prepared by BLM and the Fish and Wildlife Service for this project. In the EA, BLM acknowledges that project treatments may occur within lynx habitat, lynx analysis units, and lynx critical habitat. And it discusses these impacts and the various measures made to reduce impacts. And that's at BLM 54 to 68. I'll just note a few of those points that the BLM makes. The EA notes that project treatments will focus on areas that are not used for lynx foraging or denning. The project prohibits prescribed burning on lynx habitat. In addition, treatments are designed to enhance early stand initiation forage habitat, which provides long-term benefits to snowshoe hare, which I'm sure your honor is aware is the surrogate for measuring impacts on lynx. It also contains something called adaptive complexity thinning, which is designed to benefit lynx. And as your honor noted at the preliminary injunction stage in your order, the EA also notes that thinning in units occurring in LAUs and lynx critical habitat, in those units, seedlings and shrubs less than 3 feet tall will be retained to provide cover for snowshoe hare. Together, the project EA and the consultation documents it incorporates show that the agencies took a hard look at impacts on lynx. Plaintiffs argue that BLM failed to analyze juxtaposition of lynx habitat, considering habitat connectivity for lynx. BLM did just that when it analyzed what it calls matrix habitat, and that's primary constituent element 1D, which is matrix habitat that occurs between patches of boreal forest and which lynx are likely to travel through while assessing other patches of boreal forests, and that's at BLM 111. In the BA, BLM noted that treatments would result in a temporary reduction in horizontal cover within matrix habitat, but concluded that matrix habitat would likely host substantial numbers of snowshoe hares. And that can be found at FWS 204. And in the BIOP, the Fish and Wildlife Service also looked at impacts to matrix habitat and concluded that the effects would be insignificant. And that's at FWS 36. Now, plaintiffs argue that the project EA cannot tier to non-NEPA documents, but the EA doesn't tier to any documents at all. Tiering, as your honors are surely aware, involves where you have analysis of a broad program, plan, or policy, usually in an EIS, followed on by analyses of programs, plans, and policies that are lesser in scope or site-specific, so possibly an EA. Here, the BA and the BIOP, as I've noted, are incorporated by reference, and they're specific for this project, rather than the general analyses applicable to multiple potential projects. Incorporation of those documents into the EA was proper, and it informed BLM's analysis of the project impacts on lynx. Plaintiffs next argue that the use of the 4 lynx analysis units to analyze impacts on lynx is inappropriate. Use of those 4 LAUs in this case is appropriate because LAU boundaries are constant and they're not adjusted for individual projects. The LCAS, which plaintiffs referenced several times during this argument, that recommended the use of these LAUs. The RMP uses the LAUs, and it's used in all consultations that BLM has with the Fish and Wildlife Service in this area. Those boundaries are fixed, so they existed before this project ever existed. And so the consideration of all 4 of those LAUs is appropriate. BLM's not in a position where it can just readjust that analysis. It uses that, it's part of its RMP, so in order to be consistent with the RMP, projects need to use those lynx analysis units. In conclusion, BLM's decision to approve the project was informed by its analysis of impacts on lynx, and that decision falls within the broad zone of reasonableness under NEPA. So the court should dismiss the hard look claim. In its cumulative impacts analysis, BLM analyzed state, county, and Forest Service projects that it determined to be reasonably foreseeable. In Appendix 8 to the EA, BLM identified the location of those projects, the type of treatment, the estimated time frame, and the estimated number of acres. I would point out that these...
Mr. Duffy, it seems to me that the primary complaint that the plaintiffs have about the cumulative impacts analysis is the failure to include the Coyote Greeno project EA. I mean, as I read it. And there is, as you know, there's the supplemental briefing on whether or not the record should be supplemented with that Coyote Greeno project's environmental assessment. I noted that the defendants oppose supplementing the administrative record. The arguments on that I understand, but that you do not object to me taking judicial notice of the EA as a public document. Is that accurate?
That's correct.
Okay, all right.
On that point, so BLM analyzed these 18 other projects, the vast majority of which are state and county projects. There's 1 Forest Service project in there, but there's 0 BLM projects on that list. It did not analyze the Coyote Greeno project. There's some indication that there's indication in that project itself that BLM was notified about that project, but there's nothing in the administrative record in this case relating to that project, and I'm not going to speculate as to why that decision was made, but the decision was made to analyze these 18 projects. Now, the 18 projects that BLM analyzed in this case total 21,675 acres of the planning area. So it's not in BLM land because it's not, none of these are BLM projects, but it's within that planning area that you saw that document that came up earlier. And as to the 21,675 acres, BLM concluded that the effects would not be significant. I will say this to the Coyote Greeno project, although it's not included in that analysis, only 800 of the acres in that project even go into the planning area here. And of course, none are on BLM lands. I would posit that it's reasonably to infer that even if that project was required to be considered, and I'm not conceding that it was, the BLM would likely reach the same conclusion, that it's not, the effect to these projects is not significant. So briefly, with lynx, BLM 118, BLM explained that lynx are expected to move away from the project to more secure areas on adjacent public lands and that lynx that move onto private surrounding lands may encounter human activities that could cause them to move further away. But BLM also noted that the occupancy density of lynx is extremely low in the planning area, and the potential effect of these other projects is expected to be low. Again, I'm returning to 7 County because I think that governs everything related to the EA in this case. BLM's decision not to include one non-BLM project in the EA's cumulative impacts analysis should be entitled to deference under 7 County. And then in addition, because the Coyote Greeno project EA postdates the Clark Four-Face BA and was finalized after the Fish and Wildlife Service issued its BIOP for the project, it's post-decisional, and the agencies were not required to consider it during ESA consultation. So in sum, nothing in NEPA requires agencies to consider every project, even those that are outside of their control. And that, too, is part of the decision in 7 counties. Part of the problem with that case was that the D.C. Circuit was requiring the Surface Transportation Board to look at projects that were far downstream from the one that was at issue in this case. And there, the court stressed NEPA's text applies to the project at hand. So that's something to keep in mind. As noted, the court's role in reviewing agency compliance with NEPA is to determine whether the approval of the project falls within that broad zone of reasonableness, and here it does. Unless Your Honor has any questions on the NEPA claims, I'll turn very briefly to the FLPMA claim. Plaintiffs claim BLM failed to discuss 4 RMP management actions related to impacts on big game in the project EA. Plaintiffs claim that there's a lack of discussion and that this lack of discussion violates FLPMA. But what they fail to show is that the EA in some ways, the project itself contradicts the RMP, and that's what they need to show a FLPMA violation here. Nothing in FLPMA requires BLM to individually assess all of the hundreds of management actions that are in the RMP when it prepares an EA. Such an exercise would be untenable and contrary to NEPA. NEPA itself instructs that an EA is to be a concise document, one that shall not exceed 75 pages. And that's in the statute at 42 U.S.C. 4336 and 4336A. To just take one example, if you go through those management actions that are in the RMP, they're extremely broad and they cover tons and tons of different topics. There's a management action that requires BLM to designate Lewis and Clark National Trail Corridor and create opportunities to enjoy the trail. Obviously, I will tell you that this project does not address that management action because many of these management actions arise, with specific projects. They don't all come in, is the point I'm trying to make. And so that it would be a meaningless paperwork exercise to address all of these exogenous management actions. The focus of this project is forest health and reduction in fire risk. The project is not focused on big game specifically. That's not to say that it doesn't address big game. In fact, it does. The EA addresses big game and impacts on winter range, displacement, and forageability under each of the alternatives. And just as an example, at BLM 140, there's a discussion of moose, elk, mule deer, white-tailed deer, mountain lions, and black bears across the planning area. Consistent with the RMP, the project is designed to avoid big game habitat and contains design features to keep big game habitat intact. And that's in Appendix F of the EA. In sum, plaintiffs have failed to show any FLPMA violation, and the court should dismiss the FLPMA claim. Unless Your Honor has any questions, that's where I'll conclude.
All right, you'll have 5 minutes for rebuttal. Thank you. Ms. Bronston.
Your Honor, my rebuttal here is going to focus on the roads issue just to clear up a few, oh my goodness, I'm sorry. Just to clear up a few things that was said in the government's argument. First, Your Honor asked me to find you a citation to the project map that shows the roads that we are talking about, and that is available at BLM Supplemental Record, page 15, and that's the color version. There's a black and white version in the original record. And the way that we know for a fact that these will be open roads and that they will be haul roads is because the map itself says that they will be. The legend at the top says the brown lines on the map are haul BLM system roads, so those are roads that are in the BLM system already, and then the purple hashed line says that those are haul roads that will be added to the BLM system, and those roads are also discussed in the project documents as the existing roads. So that's what the 19.35 miles of roads is referring to. So to go to the Ackland Declaration, which is what plaintiffs submitted here, and you asked counsel for the government whether the Ackland Declaration should be considered, and the answer is yes, it should, because it goes to this argument that we're making that these roads, it's not a hypothetical, it's not a harmless error that they haven't considered the condition of project roads. And I would like to say a few things on that point. First, you asked me whether the roads in that declaration were part of this undetermined or existing category or whether those were other roads. And the answer is it's both. So number one, the picture that we submitted, number one, is a picture of a giant Kelly hump or a bermed road that prevents motorized access, and that road is currently a brown line on the map, which means it is a haul road that is currently in the BLM system. Pictures number 2 and number 3, both of those images are on purple hashed lines, meaning those roads are currently on the landscape as existing roads, but they are impassable. And again, we believe that there's nothing in the record, when I read the record, there is nothing to support defendants' claim that these will be closed roads. And in fact, the Marks Declaration says the opposite, that these haul roads will be maintained as open roads, and that's paragraph 8. And again, the council classified these roads as mapping errors. They're not mapping errors. They represent a significant change on the ground to get these roads up to haul standards. And the BLM has the responsibility to establish a baseline which has to represent reality. And all of its analyses come off of that foundation. And here, it's not considered an ministerial task or a mapping error. It is a change on the ground, and we believe that's all of the documents talking about this situation say that these roads need to be treated differently than just a simple correction of a mapping error. And notably, I wanted to point out that counsel misrepresents the Fothergill Declaration as I read it, and nothing in that declaration contradicts what plaintiffs have provided. In fact, we believe that declaration is consistent with the Ackland Declaration because in paragraph 8, he concedes that one of these haul roads is in fact bermed. He just says that it's not going to be required for the thinning project that was at issue in the preliminary injunction hearing. So he admits that that road is on the landscape. He doesn't go as far as to say this is an open road, but we believe it's consistent with what plaintiffs have provided, and that's why we think the court it should be under Lands Council considering this declaration from Christine Ackland. And I just want to take a moment to try to distinguish our two claims. And the condition of the road claim is distinct from the incidental take claim about these 19 miles of existing roads. And that is because the condition of the road is a relevant factor, and it's a relevant factor because all of these management documents say that it is, and the failure to disclose or consider that relevant factor is a violation of the ESA in and of itself. And again, the declaration that we submitted shows that this isn't a hypothetical. There's actual effects to grizzly bears. that these 19 miles of existing roads, or any roads that will be haul roads and aren't currently passable, will have to grizzly bears. And it matters here, again, because as counsel said, there's not a lot of secure habitat on this landscape. And the way that the BLM has defined secure habitat means that every one of these brown roads on this map precludes a finding of secure habitat in that area. Whereas if that road that is bermed has effectively prevented motorized access for an unknown amount of time since that berm was put in there, that means that that road actually has provided some level of habitat security. And under the calculations, it would provide secure habitat if they had considered the actual condition of the road. And that is the heart of our claim here. We know that grizzly bears are using this area. We know this area is a keystone for dispersing grizzly bears out of the NCDE. They're finding their way. There are news stories all the time. We know this habitat is being used by grizzly bears. So to just look at the numbers, to say there's not going to be any effect because we have so many roads already, I mean, it effectively allows them to build these roads anywhere they want because they're already saying it's not being used. And we just know that's not true. So, Your Honor, again, the agency's failure to consider that element is a failure to consider a relevant factor. And in conclusion, we ask the court to find for plaintiffs on all of our claims. Thank you.
Your Honor, I'd just like to make 4 points in response to plaintiff's rebuttal. First of all, in looking at the map that plaintiffs point out, where it says add to system, it's important again to recognize that add to system is a reference to the FAMS database, not the inventoried roads that were done in 2021 that are listed out road by road, mileage by mileage in the record. Second, with respect to the Marks Declaration, again, this is an issue with reading the word open as passable versus open as available to the public. What the Marks Declaration says, I apologize, Your Honor, brought up too many things. I apologize. I think I left it. Yep, left it right there. Your Honor, paragraph 8, that sentence actually says is BLM has an obligation to maintain roads that are open to the public for public safety. So roads that are open to the public must be maintained for public safety. It doesn't say it has to maintain roads as open. It means the ones that are open to the public should be safe for the public to use. That's all it says. With respect to the condition of the road, again, the condition of the road has to be its inventoried status, what the agency has said the road is used for. And it's important to note that under the BLM's RMP, an impassable road can remain on the inventory as long as it's going to be used in the future. BLM did that. To the extent that any roads are impassable, they intend to use them again as a haul route in this project. And so they remained on the inventoried system. That means they're included in that 374.8 miles of roads for the total linear density.
Some of the 19 miles are.
Yes, Your Honor.
About 5 miles that were not.
That's correct, Your Honor. 5.6 miles are not in that. But all of the other roads for this project are already in there. And the reason that that's important is because that's how the agency analyzed the roads and their effects on grizzlies as being open and being used by cars. And certainly plaintiffs have taken the exact opposite position of what they're asserting here. Had BLM removed these roads from their inventory without properly closing them, for example, plaintiffs have argued in other cases that closing roads isn't enough to bring grizzlies back to the area, and that roads shouldn't be removed from the inventoried status once they've been closed. So plaintiffs' position here is directly contrary to what they've said in other cases. What the agency did here is exactly what they're supposed to. They want to use these roads again. They didn't remove them from the system, so they're still there. They've been analyzed in the RMP and in the project-specific BIOP as being open and available and included in the road density analysis. There's nothing more for the agency to do with respect to those impassable roads. So for those reasons, Your Honor, we'd ask that you uphold this project. Thank you.
All right. Well, thank you very much, counsel. Very helpful. The matter is fully submitted, and we'll get an opinion out here. I'll get an opinion out as quickly as I can. And we'll be in recess. Thank you.
Oh, it's not on the thumb drive, because it was only a few pages, we filed it on ECF.
Oh, okay.
Is that all right,
Yeah,
or would you
no,
like us to
that's fine. I
private?
can let her know that. Do you
Okay.
happen to know?
Don't have the ECF number.
That's all right.
Hold on, I may have, let me check. Oh, okay, don't.
I think I filed it the same day as our
43 or something.
PI. Yeah, I think it was 43, because I think it was right after our PI brief.
perfect.
Yeah.
Okay, good, thank